Let me start with this, because if you're watching this might be exactly where you are right now. You've booked your dream venue, you paid a big deposit, and now you want out. Maybe you found something better. Maybe your budget changed. Maybe the wedding is off. Or maybe, and this is the one we're seeing more and more, the venue is not what you thought it was going to be. And now the question becomes, can I get out of this contract? And can I get my money back? And here's the answer no one likes. Sometimes yes, sometimes no. And sometimes it depends on details you didn't even know mattered. Hi, I'm Shari Rivkind, co-founder of Bridelawyer, and I have been practicing law for over 38 years. And this right here is one of the most common, emotional, and expensive issues we deal with. So today I'm going to walk you through what actually matters, what your rights really are, and the mistakes that can cost you thousands. Let me tell you about a real situation we had recently. A couple booked a venue. It looked beautiful. It sounded like a package deal. Venue, catering, everything handled. It was perfect, except it wasn't. The venue owner had made arrangements with the caterer, but the contract only covered the venue, not catering. And the money was paid to the venue owner. So what happens next? The caterer says, wait, we never agreed to this pricing. Now the couple is stuck in the middle. The venue owner starts scrambling, offering concessions, trying to fix it, trying to keep the deal alive. But the couple, they've lost trust. And now they're asking us, can we get out of this? And here's where it gets very real. Legally, the contract didn't fully cover what was promised. Practically, the venue had the deposit and time was ticking. Litigation would have taken months. The wedding date was coming. So what did they do? They negotiated. They pushed. They got concessions. And they stayed. Not because it was perfect, but because legally and practically, it was the best move. And that's the first big lesson. This is not just about what's right, it's about what's realistic. Let's talk about the most common reasons people come to us. Number one, we found a better venue. This is the hardest one because legally, that's not a reason. That's buyer's remorse. Courts don't cancel contracts because you upgraded your taste. Number two, we can't afford it anymore. This happens all the time. Budgets change, life happens. But again, unless the contract says otherwise, that's not usually grounds to cancel. Number three, the wedding is off. Now this one feels like it should matter. Emotionally, it matters a lot. Legally, not necessarily. The venue didn't cause the breakup, so the contract doesn't just disappear. Number four, the venue changed. Now this is where things get interesting, because this is where legal arguments start to matter. We had two recent cases involving views. Beautiful venues, gorgeous surroundings, and then construction. Scaffolding, block views, not exactly what was advertised. But here's the twist. In one contract, it said no guarantees as to the surrounding conditions. That couple, they had a much harder case. In the other, the contract only described the interior space, didn't mention the views at all. That couple, they also had a problem. And this is the point. Facts matter. Language matters. Word matters. Now let's talk about one of the most common calls we get. It's always right before a payment is due. And the question is, can we just not pay? And here's the answer. You can, but should you? That's a different question. Because if you stop paying and you don't have a legal basis, you may be the one in breach. If the venue has already failed to deliver something important and you have proof, then yes, sometimes withholding payment paired with a strong legal letter can be strategic. But if you just stop paying, you could be making your situation worse. Now let's talk about what really controls these cases. Because it's not emotion, it's not fairness, It's this, the contract. Number 1, payment schedules. Most venue contracts have a large deposit, often 50%, additional payments over time, and less refund as you get closer to the date. Number 2, liquidated damage clauses. Many contracts say, you cancel, we keep the money. But here's the legal reality. Courts don't love penalty clauses. They want fairness. Which brings us to a key concept, mitigation. The venue usually has a duty to try to rebook your date. If they do, their damages go down. Number 3, assignment clauses. This is a big one people miss. Can you sell your contract? Transfer it. Find another couple. Only if the contract allows it. If there's an assignment clause, you may need venue consent, and that consent usually has to be reasonable. If there's no clause, you're going to need written permission. Number 4, deposits versus retainers. This is subtle, but it's important. If it says non-refundable retainer, that's much stronger language. Here's the truth no one tells you. Most of these cases don't end up in court. They end up in negotiation because both sides have risk, both sides have costs, and both sides usually want to avoid a fight. So if you're in this situation, pause before you stop paying, before you panic, before you assume you're stuck or that you're free. Because the answer is almost never that simple. And if you want to really understand how contracts like this work, take a look at our book, I'm Getting Married. What do I do now? It's available on Amazon. And follow us at Bridelawyer.com because this is exactly